In this video, I am going to explain how you can DMCA another user and make it stick. Now, as you know, DMCA was set up to protect people from having their content stolen. Here's how you use the DMCA. First of all, let's say that you write music and insert that into one of your videos. Now let's say somebody mirrors that video without permission. As long as you have the original copy, for example FL Studio says, in FLV format, then you can DMCA that video and make it stick. According to my researcher, material is copywritten from the moment you create it. All you need is the proof that it belongs to you. Now according to Templetons.com, there are 10 myths you need to know about regarding copyrights. Here are the myths along with the information. 1. If it doesn't have a copyright notice, it's not copyrighted. This was true in the past, but today almost all major nations follow the Berne Copyright Convention. For example, in the USA, almost everything created privately and originally after April 1, 1989, is copyrighted and protected whether it has a notice or not. The default you should assume for other people's works is that they are copyrighted and may not be copied unless you know otherwise. There are some old works that lost protection without notice, but frankly you should not risk it unless you know for sure. It is true that a notice strengthens the protection by warning people and by allowing one to get more and different damages, but it is not necessary. If it looks copyrighted, you should assume it is. This applies to pictures, too. You may not scan pictures from magazines and post them to the net, and if you come upon something unknown, you shouldn't post that either. The correct form for a notice is copyright, dates, by author/owner. You can use C in the circle copyright instead of copyright, but C has never been given legal force. The phrase, all rights reserved, used to be required in some nations but is now not legally needed most places. In some countries it may help preserve some of the moral rights. 2. If I don't charge for it, it's not a violation. False. Whether you charge can affect the damages awarded in court, but that's main difference under the law. It's still a violation if you give it away, and there can still be serious damages if you hurt the commercial value of the property. There is a USA exception for personal copying of music, which is not a violation, though courts seem to have said that doesn't include wide-scale anonymous personal copying as Napster. If the work has no commercial value, the violation is mostly technical and is unlikely to result in legal action. Fair use determinations do sometimes depend on the involvement of money. 3. If it's posted to use and it's in the public domain. False. Nothing modern and creative is in the public domain anymore unless the owner explicitly puts it in the public domain. Explicitly, as in you have a note from the author/owner saying, I grant this to the public domain. Those exact words or words very much like them. Some argue that posting to using it implicitly grants permission to everybody to copy the posting within fairly wide bounds, and others feel that using it is an automatic store and forward network, where all the thousands of copies made are done at the command rather than the consent of the poster. This is a matter of some debate, but even if the former is true, and in this writer's opinion we should all pray it isn't true, it simply would suggest posters are implicitly granting permissions for the sort of copying one might expect when one posts to using it, and in no case is this a placement of material into the public domain. It is important to remember that when it comes to the law, computers never make copies, only human beings make copies. Computers are given commands, not permission. Only people can be given permission. Furthermore, it is very difficult for an implicit license to supersede an explicitly stated license that the copier was aware of. Note that all this assumes the poster had the right to post the item in the first place. If the poster didn't, then all the copies are pirated and no implied license or theoretical reduction of the copyright can take place. Copyrights can expire after a long time, putting something into the public domain, and there are some fine points on this issue regarding older copyright law versions. However, none of this applies to material from the modern era, such as net postings. Note that granting something to the public domain is a complete abandonment of all rights. You can't make something PD for non-commercial use. If your work is PD, other people can even modify one byte and put their name on it. You might want to look into Creative Commons style licenses if you want to grant wide rights. 4. My posting was just fair use. See FF notes on fair use and links from it for a detailed answer, but bear the following in mind. The fair use exemption to U.S. copyright law was created to allow things such as commentary, parody, news reporting, research and education about copyrighted works without the permission of the author. That's vital so that copyright law doesn't block your freedom to express your own works, only the ability to appropriate other people's. Intent and damage to the commercial value of the work are important considerations. Are you reproducing an article from the New York Times because you needed to in order to criticize the quality of the New York Times, or because you couldn't find time to write your own story, or didn't want your readers to have to register at the New York Times website? The first is probably fair use, the others probably aren't. Fair use is generally a short excerpt and almost always attributed. One should not use much more of the work than is needed to make the commentary. It should not harm the commercial value of the work in the sense of people no longer needing to buy it, which is another reason why reproduction of the entire work is a problem. Famously, copying just 300 words from Gerald Ford's 200,000-word memoir for a magazine article was ruled as not fair use, in spite of it being very newsworthy, because it was the most important 300 words. Why he pardoned Nixon. Note that most inclusion of text in follow-ups and replies is for commentary, and it doesn't damage the commercial value of the original posting if it has any, and as such it is almost surely fair use. Fair use isn't an exact doctrine, though. The court decides if the right to comment overrides the copyright on an individual basis in each case. There have been cases that go beyond the bounds of what I say above, but in general they don't apply to the typical net claim of fair use. The fair use concept varies from country to country and has different names, such as fair dealing in Canada and other limitations outside the USA. Facts and ideas can't be copyrighted, but their expression and structure can. You can always write the facts in your own words, though. See the DMCA alert for recent changes in the law. 5. If you don't defend your copyright, you lose it. Somebody has that name copyrighted. False. Copyright is effectively never lost these days, unless explicitly given away. You also can't copyright a name or anything short like that, such as almost all titles. You may be thinking of trademarks, which apply to names, and can be weakened or lost, if not defended. You generally trademark terms by using them to refer to your brand of a generic type of product or service. Like a Delta airline. Delta Airlines owns that word applied to air travel, even though it is also an ordinary word. Delta Hotels owns it when applied to hotels. This case is fairly unusual as both are travel companies. Usually the industries are more distinct. Neither owns the word on its own, only in context, and owning a mark doesn't mean complete control. See a more detailed treatise on this law for details. You can't use somebody else's trademark in a way that would steal the value of the mark, or in a way that might make people confuse you with the real owner of the mark, or which might allow you to profit from the mark's good name. For example, if I were giving advice on music videos, I would be very wary of trying to label my works with a name like MTV. You can use marks to criticize or parody the holder as long as it's clear you aren't the holder. 6. If I make up my own stories, but base them on another work, my new work belongs to me. False. U.S. copyright law is quite explicit that the making of what are called derivative works based or derived from another copyrighted work is the exclusive province of the owner of the original work. This is true even though the making of these new works is a highly creative process. If you write a story using settings or characters from somebody else's work, you need that author's permission. Yes, that means almost all fan fiction is arguably a copyright violation. If you want to publish a story about Jim Kirk and Mr. Spock, you need Paramount's permission, plain and simple. Now, as it turns out, many, but not all holders of popular copyrights turn a blind eye to fan fiction, or even subtly encourage it because it helps them. Make no mistake, however, that it is entirely up to them whether to do that. There is a major exception: criticism and parody. The fair use provision says that if you want to make fun of something like Star Trek, you don't need their permission to include Mr. Spock. This is not a loophole. You can't just take a non-parody and claim it is one on a technicality. The way fair use works is you get sued for copyright infringement, and you admit you did copy, but that your copying was a fair use. A subjective judgment on, among other things, your goals is then made. However, it's also worth noting that a court has never ruled on this issue, because fan fiction cases always get settled quickly when the defendant is a fan of limited means, sued by a powerful publishing company. Some argue that completely non-commercial fan fiction might be declared a fair use if courts get to decide. You can read more. 7. They can't get me. Defendants in court have powerful rights. Copyright law is mostly civil law. If you violate copyright, you would usually get sued, not be charged with a crime. Innocent until proven guilty is a principle of criminal law, as is proof beyond a reasonable doubt. Sorry, but in copyright suits, these don't apply the same way or at all. It's mostly which side and set of evidence the judge or jury accepts or believes more, though the rules vary based on the type of infringement. In civil cases, you can even be made to testify against your own interests. 8. Oh, so copyright violation isn't a crime or anything? Actually, in the 90s, in the USA, commercial copyright violation involving more than 10 copies and value over $2,500 was made a felony. So watch out. At least you get the protections of criminal law. On the other hand, don't think you are going to get people thrown in jail for posting your email. The courts have much better things to do. This is a fairly new, untested statute. In one case, an operator of a pirate BBS that didn't charge was acquitted because he didn't charge, but Congress amended the law to cover that. 9. It doesn't hurt anybody. In fact, it's free advertising. It's up to the owner to decide if they want the free ads or not. If they want them, they will be sure to contact you. Don't rationalize whether it hurts the owner or not. Ask them. Usually that's not too hard to do. Time passed. Clarinet published the very funny Dave Barry column to a large and appreciative Usenet audience for a fee, but some person didn't ask, and forwarded it to a mailing list, got caught, and the newspaper chain that employs Dave Barry pulled the column from the net, pissing off everybody who enjoyed it. Even if you can't think of how the author or owner gets hurt, think about the fact that piracy on the net hurts everybody who wants a chance to use this wonderful new technology to do more than read other people's flamme wars. 10. They emailed me a copy so I can post it. To have a copy is not to have the copyright. All the email you write is copyrighted. However, email is not, unless previously agreed, secret. So you can certainly report on what email you are sent and reveal what it says. You can even quote parts of it to demonstrate. 11. So I can't ever reproduce anything. Miss 11, I didn't want to change the now famous title of this article, is actually one sometimes generated in response to this list of 10 myths. No, copyright isn't an ironclad law on what can be published. Indeed, by many arguments, by providing reward to authors, it encourages them to not just allow, but fund the publication and distribution of works so that they reach far more people than they would if they were free or unprotected and unpromoted. However, it must be remembered that copyright has two main purposes, namely the protection of the author's right to obtain commercial benefit from valuable work, and more recently the protection of the author's general right to control how work is used. While copyright law makes it technically illegal to reproduce almost any new creative work, other than under fair use, without permission, if the work is unregistered and has no real commercial value, it gets very little protection. The author, in this case, can sue for an injunction against the publication, actual damages from a violation, and possibly court costs. Actual damages means actual money potentially lost by the author due to publication, plus any money gained by the defendant. But if a work has no commercial value, such as a typical email message or conversational USENET posting, the actual damages will be zero. Only the most vindictive and rich author would sue when no damages are possible, and the courts don't look kindly on vindictive plaintiffs unless the defendants are even more vindictive. I will have a link to the site that I read from so that you may use it to help you in DMCA claims.